2 weeks ago, New York Federal Reserve President Bill Dudley dropped a bombshell in the Senate by admitting that until just recently, the Justice Department has been simply unwilling to prosecute Wall Street.
And you will continue to make public statements that the era of too big to jail is behind us?
I think we made a lot of progress because we're now finding firms guilty, where we were not willing to find those firms guilty before because we were worried that if we found them guilty, that it could somehow potentially destabilize the financial system.
Dudley's admission that the DOJ has been unwilling, rather than unable, to prosecute Wall Street undercuts years of Justice Department excuses about why it could never prosecute any bailed-out banks or their executives. It also buttresses one of the most shocking revelations by Frontline's Untouchables episode.
We spoke to a couple of sources from within the criminal division, and they reported that when it came to Wall Street, there were no investigations going on, there were no subpoenas, no document reviews, no wiretaps.
While the Untouchables all but proved that the DOJ's total failure to prosecute Wall Street was the result of a policy choice, Bill Dudley has now made it official. With that backdrop, this video examines the DOJ's increasingly desperate efforts to conceal its policy after the Untouchables set off a national uproar. This includes fabricating witnesses, fabricating evidence, and lying to Congress, and even today involves using federal court dockets as a means to cover up its massive deception. As we shall see, the untrammeled growth of that deception reflects the root function of Eric Holder's Justice Department as an instrumentality of Wall Street crime. As often is the case with criminal alibis, the executive branch story about Wall Street prosecutions has been a nose of wax from the very beginning. The first lie was that Wall Street hadn't committed any crimes, which was supposedly why we needed new laws like Dodd-Frank.
I can tell you just from 40,000 feet that some of the most damaging behavior on Wall Street, in some cases some of the least ethical behavior on Wall Street, wasn't illegal. That's exactly why we had to change the laws.
That lie fell apart when former Fed Chairman Alan Greenspan, to the visible distress of Ben Bernanke, admitted that Wall Street had in fact perpetrated enormous criminal frauds, for which the remedy wasn't the creation of new laws, but rather the enforcement of existing law.
I think there was rampant fraud in a lot of what was going on in these markets, but my general judgment is that there are two fundamental reforms that we need is to get adequate capital and two, to get far higher levels of enforcement of fraud statutes. Existing ones, I'm not even talking about new, things were being done which were certainly illegal and clearly criminal in certain cases, which
the administration changed its no prosecution story radically in December 2012, when HSBC admitted to criminal money laundering violations. Eric Holder claimed, without a shred of evidence, that prosecuting the bank would destabilize the financial system. The DOJ then openly refused to enforce the law. It was a watershed event not just in American history, but in legal history. For 800 years, the rule of law had always been the ultimate authority, having trumped the power of men, known as kings, to make up rules as they went. This was the iconic achievement of the Magna Carta. Eric Holder's decree purported to undo that by subordinating the law to his naked claim of financial destabilization. The question was who stood behind that claim. The answer came the next week in another case, this one against UBS, a client of Holder's old law firm. The DOJ again announced it wouldn't prosecute, despite the Swiss bank's admitted role in criminally rigging the LIBOR interest rate. Holder said the decision was based on experts outside of the Justice Department.
The impact on the stability of the financial markets around the world is something that we take into consideration. We reach out to experts outside of the Justice Department to talk about what are the consequences of actions that we might take.
At the time, Holder didn't know that Frontline's Untouchables would soon set off 2 congressional investigations into the names of these experts. By late January of 2013, senators from 2 powerful committees had demanded that the DOJ disclose their names and compensation agreements. This set off a Chinese fire drill inside the Justice Department, which couldn't get its story straight on where its own experts had come from. Lanny Breuer immediately tried to set the DOJ party line by turning the phrase outside experts on its head, claiming it meant government regulators. Not only did Breuer's story fail to check out, as we shall see, but it conflicted from the start with his own prior distinction between regulators and experts, whom he separately identified in trying to rationalize the DOJ's prosecutorial failures.
In any given case, I think I and prosecutors around the country being responsible should speak to regulators, should speak to experts.
1 month later, Senator Grassley asked why the DOJ hadn't answered his letter. In trying to duck the question, Eric Holder inadvertently threw Lanny Breuer under the bus.
Well, we'll endeavor to answer your letter, Senator. We did not, as I understand it, retain experts outside of the government in making determinations with regard to HSBC.
Holder's express acknowledgement of, quote, experts outside of the government, unquote, was a dead giveaway that the scope of the term experts wasn't limited to government regulators, again contrary to Breuer's claim. An investigation by the House began unraveling Breuer's yarn even further 2 days later. To prepare for hearings, the House demanded that the DOJ turn over all records reflecting any economic analyses of potential prosecutions, including all DOJ requests for such analyses from regulators. These document requests quickly revealed that the sought-after records didn't exist, at least not from any government agency. The U.S. Treasury confirmed that it had never provided such an analysis to the DOJ, and in fact had only one remotely related internal document at all, which it never shared with the DOJ in any event. Other financial regulators, including the Federal Reserve, likewise confirmed that there isn't the first trace of any destabilization analysis anywhere in the entire government. Ben Bernanke could identify only one remotely relevant meeting between the DOJ and Fed staffers, but said the topic of collateral consequences was never discussed, even in general terms. As more and more evidence gave lie to the DOJ's claim that its collateral consequences consultations had been only with regulators, not one of whom was ever found, the House called a hearing. It sent Holder a letter setting the date for May 22nd. The Financial Services Committee asked that the DOJ make Deputy Attorney General James Cole available to testify. With its story crumbling apart less than a week before the hearing, the DOJ's lies went into overdrive. Its first gambit was to send a letter to the House that literally defied reality. The DOJ claimed that it didn't know of any consultations with private, non-governmental, third-party entities about the collateral consequences of prosecuting the too big to fail banks. The DOJ's denial that it had in fact met repeatedly with private parties to discuss collateral consequences is blatantly false. What's so uncanny is how closely its awkwardly worded denial tracks a speech posted on the DOJ's own website, which proves that every word of its denial is false. The speech had been given 8 months earlier to the New York City Bar by Lanny Breuer. In it, he practically brags about the bank CEOs and lawyers who routinely filled his conference room to present opinions about the collateral consequences of prosecuting their companies.
We are frequently on the receiving end of presentations from defense counsel, CEOs, and economists who argue that the collateral consequences of an indictment would be devastating, just devastating for their client. In my conference room over these past years, I've heard sober predictions that a company or a bank might fail if we indict, that innocent employees could lose their jobs, that entire industries could be affected, and that even global markets will feel the effects.
But now, in May 2013, with the Congressional hearing about to reveal who gave these highly material opinions, the DOJ did a complete about-face. It now said that consultations with private entities never took place, even though Lanny Breuer's speech proves that they did. The DOJ maintained its discredited story that collateral consequences opinions came from regulators. Again, there was just one slight problem. There are no such regulators. The DOJ simply made them up to divert attention from the real experts whom Lanny Breuer, by his own admission, routinely consulted before exonerating their companies. How the DOJ had been forced into this surreal fabrication is clear from the timeline. In December 2012, when Eric Holder first announced that the rule of law had been trumped at the behest of outside experts, it might have seemed like a clever way to describe the CEOs and lawyers in Breuer's conference room. At the time, however, Holder had no way of foreseeing that 2 congressional investigations would put his fib through a meat grinder. When precisely that misfortune occurred, the DOJ turned its little white lie into a Frankenstein by inventing fake experts who don't exist to stand in for the real experts in Breuer's conference room. On May 16th, the die was cast on the DOJ's experts. They were domestic and foreign regulators, not the CEOs and lawyers in Brewer's conference room, even though these are the only people ever known to have provided collateral consequences opinions. The question is why the DOJ would invent fictitious experts instead of just copying to, or at least spinning, Holder's fib. The answer is that the DOJ planned to use its collateral consequences doctrine as the legal justification for its failures at the hearing. The true identities of the DOJ's experts, though, expose the doctrine as a sham used by criminals as a get-out-of-jail-free card. It's merely a pretense to justice. Accused criminals, such as the CEOs and their lawyers in Brewer's conference room, will always exonerate themselves, which, as Brewer admitted, was the whole purpose of their collateral consequences opinions. The DOJ's flawless record of Wall Street non-prosecution isn't the fluke outcome of real legal analyses, as the DOJ would have it. It's the result of policy, exactly as Dudley admitted. What this episode reveals is that the DOJ would sooner lie to Congress than it will do anything to jeopardize Wall Street's sovereign privilege of criminal immunity, otherwise known as the collateral consequences doctrine. What's almost as disturbing is how Congress reacted to the lie about experts. Rather than calling out the DOJ, the House quietly changed its pre-hearing memo, which until then had identified the DOJ's witness as Deputy Attorney General James Cole. The new witness was Maithili Raman. Little did anyone know that Raman would end her 17-year Justice Department career after the hearing and join Lanny Brewer as a partner at Eric Holder's old firm, Covington & Burling. As explained in Part 1, Covington's clients constitute the who's who of bailed-out criminal banks. These same banks were the subjects of the hearing at which soon-to-be Covington partner Maithili Raman was the only witness. C-SPAN didn't televise the hearing, so this burlesque of federal governance was recorded only in writing. Briefly summarized, Raman not only concealed the experts' identities, and thus the fact that the DOJ made them up, but palmed off the collateral consequences doctrine as legitimate. In fact, the sham doctrine was fabricated out of thin air 15 years ago, by none other than Eric Holder. Raman's success was greatly facilitated by the epic ineptitude of Congress, which failed to pose any questions at all on a host of fundamental issues. Raman concealed the identities of the DOJ's experts by repeatedly claiming that many banks were still the subjects of ongoing investigations, despite the DOJ's public refusal to prosecute them. Question: can you please identify the regulators by name whom you are contacting? Answer: I am extremely limited in what I can say about open investigations. Aside from not answering the question responsively, Raman failed to disclose why the DOJ had suddenly begun keeping investigations of banks like HSBC open after refusing to prosecute. In the past, the DOJ would either not file a case at all, or it would dismiss the case from the court's docket once it announced its decision not to prosecute. The DOJ's sudden deviation from both well-established procedures raised eyebrows on the federal bench. In HSBC, Judge John Gleeson wondered why the DOJ neither declined to prosecute the bank on the one hand, nor extinguished the case after it had been brought on the other. Instead, the DOJ took a third path, which Judge Gleeson deemed novel, by keeping the prosecution open for at least 5 years. Gleeson speculated that perhaps the filing and maintenance of criminal charges was intended to produce a public relations benefit for the government. We now know from Raman's testimony that the DOJ's new practice produced a second benefit, namely, grounds for the DOJ to claim that the identities of collateral consequences experts are a big secret. Under the Freedom of Information Act, for example, the Justice Department can use statutory exemption 7A as a blanket to conceal everything about collateral consequences as part of an investigation that's allegedly ongoing. By keeping unprosecuted criminal cases open, the DOJ is able to put the seal of federal court over its bogus cover story, in which unnamed government experts opine that prosecutions will have unspecified consequences. To expose the charade taking place under its own nose, all Congress had to do was ask Raman for a complete and documented list of the CEOs and lawyers that Brewer had told the New York City Bar about. According to the DOJ, after all, its experts came exclusively from government. Raman's confidentiality claim thus couldn't shield anyone Lanny Brewer had referred to. The congressional failure to ask for these names is breathtaking. Congress likewise failed to ask Raman to name a single case where the DOJ considered collateral consequences, but put bankers in prison anyway. The answer to that question, that no such cases exist, would have separately exposed the collateral consequences doctrine as the get-out-of-jail-free card that it is, at least for bailed-out banks. For her own part, Rahman rationalized the DOJ's failures by repeatedly invoking the doctrine. What she failed to mention is that Eric Holder himself created that doctrine from scratch in 1999. It has no support whatsoever in any statute or case law. It's no more than a self-serving edict delivered by Wall Street's highest-ranking agent from the one branch of government that has no business writing law, much less outsourcing sovereign privileges. Any lingering doubts about the extent to which Wall Street clients of Covington and Burling have been controlling the DOJ will be erased by the next video, as will any hope that the DOJ's heiress apparent will pose any challenge to the command of U.S. law enforcement by criminals.